Hi there, welcome to Employment Hour in 30. I'm John Scholes. As usual, Lior Samfiru from the Samfiru Tumarkin law firm with all the knowledge telling you about your workplace rights and how it works in your workplace. Could be severance, could be harassment, it could be your boss. Maybe you are the boss. There's always vital information given out on this show that you want to keep right up here in your noggin moving forward, because it's the place where you spend most of your time. We're talking about your workplace and your job. So we've got a lot of stuff to cover today, Lior. We're going to talk about employee or independent contractor. This is, for the average person, very muddy waters because they don't understand the difference quite often, and they've been, as you call, misclassified. So we'll get to that here in just a bit. We're going to talk about the severance pay calculator because that is an amazing tool. And first, so we do a week that was. What's been going on with you, pal?
Well, what's been going on, John, is I've always had the privilege, continue to have the privilege to speak with a lot of people every day. People that find themselves in a difficult position at work, and I hope that by talking to me, we help alleviate some of those issues, alleviate some of those concerns, and hopefully help them understand that there are solutions to workplace problems. That is exactly why we are here. We're here to tell you that there are solutions. The law is actually quite good when it comes to employment law, when it comes to workplace rights. So if you want to know what your rights are, good place to start is right here with us every single week on this station, because we talk about important things. We talk about relevant things. We talk about things that are going to impact you every single day on your job. And if you want to learn, tune in. Otherwise, you can always reach out to me anytime to talk privately. We'll give you that contact information throughout the show. And week there was where I tell you about a situation that came across my desk just over the past few days, where I think there's some important lessons to be learned for our viewers. So I spoke with a gentleman that had worked for a company, or started with a company 19 years ago. Worked there for a very long time. But about 6 years ago, he decided to leave. Okay. He thought, maybe the grass is greener somewhere else, and he decided to leave and go work for another company. He only lasted there for 3 months. He realized he made a mistake. So he contacted his old company and said, I want to come back. They were happy to take him back. He was a good employee. He knew what he was doing, and they took him back. So he really had only been gone for 3 months. Fast forward to now. 6 years later, the company says, unfortunately, restructuring, we have to cut some costs, and out you go. You no longer have a job. And of course, they pay him severance. Except the severance they want to pay him is based on 6 years of employment.
When he came back.
When he came back. So remember, he started there 19 years ago, worked for 13 years, and then left for 3 months, came back, worked another 6 years. So they're saying you're a 6-year employee. We're going to pay you severance on that basis. He was surprised. In fact, I think he actually forgot that he had been gone for 3 months. It's such a short period of time. And he called me wanting to know if that is right. Is he really a 6-year employee, or is he a 19-year employee? Well, John, the answer is, and hopefully our regular viewers know this, he is a 19-year employee. When you have a long employment and there's a gap, especially if that gap is short, oftentimes we can disregard that gap. Because again, 3 months is a very short period of time in comparison with 19 years of service. They didn't really hire him back as a new employee. They hired him back because of his seniority, because of his service. So now when they let him go, he is a 19-year employee, and they have to pay him severance as a 19-year employee, which for him could easily be 18 months. So I wanted to raise this because a lot of people may find themselves in that situation where employment may not be continuous. You may have gaps, and even in a situation where you have a gap, the law may consider that gap as if it doesn't exist, and you get credit for your full service, and that's especially important when it comes to severance.
First question, though, he left on his own terms, so it still applies. It's not like they let him go and said, we made a mistake 3 months ago, we want you back.
Absolutely.
So it still qualifies for the entire 19 years.
Absolutely. He left. Again, they didn't let him go. He decided to leave his own volition, and he's the one that initiated coming back. They didn't go after him. But even in that situation, John, because of that break was so short. Listen, if the break was 2 years, I may be feeling differently about it. But given the fact that the break was so short, 3 months in a span of 19 years, that's disregarded. Doesn't matter why he left, how he came back, frankly. So he's a 19-year employee, and what does that mean for severance? Whereas if he was only a 6-year employee, he'd probably be looking at 6, 7, 8 months of severance. Because he's a 19-year employee, he's looking at anywhere from 18 to 20 months of severance. Huge deal. In the 6 figures, that delta, the difference. So because of that, it's important to know how much service you actually have.
You say, yeah, it's funny you mentioned 2 years would be a different story. Now, he was 3 months. So between those two, where's the threshold where this no longer applies? Where you can get the full severance?
You're right. It's a great question. It does depend. The longer you work, the more of a break we can disregard.
Okay.
And we also look at things such as, did the company explicitly or implicitly recognize your past service? Did they treat you like a new employee or they didn't?
Wow.
So there's a number of factors. So really, what I'm trying to say here is if you're if you have service that's not counted by the company when it comes to severance, you got to give me a call. We got to talk about that because you actually may get credit for service you had in the past.
EmploymentHourTV.ca is a great website. You can find information about this show, where to carry it, as well as our radio show, which we're into year 7, I think, of the radio show. And from there, we take a lot of phone calls. We play them back. And I know you like to dissect and comment on them. So we'll get to our first one for today.
I work for a company that I'm in technical sales, and I've been there for 22 years. We have a manager that he's doing everything in his power to ensure that I don't make my sales target. I have good performance reviews for the past 22 years. And also, they're wanting to do my territory I already have and another full-time territory for the same salary, force me into doing another job.
Double the workload, right?
Double the workload,
Yeah.
not double the pay, unfortunately. And making it harder for him to earn income, to make his targets. Well, that's a problem because a company can't do that. A company can't put things in your way. They can't put these obstacles in your way, because if they do, that's a breach of terms of employment. And certainly if a company is going to double your workload and not pay you more, then no, that's a breach of the terms. That's not what you've agreed to. So what does this mean for this person? Given everything that he said, companies not treating him properly, putting obstacles in his way, doubling his workload, not paying him properly, that is a constructive dismissal. They've changed the deal. That's not what he signed up for, okay? They now created a situation that's different. And you may find yourself in the same situation where your boss does something that creates a different work environment or a work situation or more workload. You don't have to accept that. You can treat that as a termination and get severance. So that's what he can do. He can treat this as a termination and get severance. So what I've done is I've taken his information and I've plugged it into the severancepaycalculator.com website to find out how much he's actually owed. So let's look at the screen and see how much he'd be actually owed. So he's in a sales role, 22 years of service. I picked an age, let's say he's 60 or 61 years old. Someone in his situation would be owed, as you see on the screen,
No kidding.
20 to 24 months of pay. And again, 20 to 24 months, and this is a situation where the company has not let him go. Remember, the company did not fire him. They didn't terminate his employment. It's a situation where he can require them to pay him that. He can require them to terminate his employment because of what the company has done. And that is what a constructive dismissal is all about, when you can require the company to effectively treat the situation as a termination and get your severance. And severancepaycalculator.com just showed us how much he's owed.
What would be the problem or the pitfall if you just laid down and accepted it and didn't do anything about it? I
Well,
called you, in other words, right?
Well, the key word there is accepted it. Once you've accepted it, then you're stuck. You've accepted it. You can't say, now I don't like it. So when you don't say anything, when you continue working, the law considers you to say, yes, I'm okay with it. I've agreed, I've accepted. And if you've accepted, then you're stuck. And then the fact that you have double the workload, the fact that your employer is treating you not so well, you can't do anything about it. So when you're facing that kind of a problem in the workplace, when there's an obstacle, there's an issue, you have to deal with it right now. That window is a small one, is a short one. You usually would have a few weeks to deal with it. Anything beyond that, you may be considered to have accepted, and that's a problem.
Again, EmploymentHourTV.ca, the place to find out where you can catch our radio show that we do every week. And from it, phone call number 2.
I got injured at work. I had to go off sick. I had no sick pay, so I had to go on unemployment insurance. My company sent me a letter saying, you no longer have a job and catch you later. They didn't even send me a record of employment. I want to know if there's a time limit that you can go after a company for severance pay.
So there's a couple things here to discuss. Number one is if she's being let go because she has a medical condition, because she's unable to work, well, that is a human rights violation, okay? That you can't be let go because you're off work. And if she's been let go while she's off work, the company is gonna have a very difficult time to say, no, there was really another reason. That's not why we let her go. It's going to be very difficult to do. So right there's a human rights violation. But even putting that aside, of course she's owed severance. The fact that you may be let go while you're on a disability leave, while you're off work, when you're not working, it does not mean you don't get severance. You get the exact same severance as if you were still working. So she gets severance. Again, we don't know all her factors. We don't know her age, her position, length of employment, so I can't tell you how much she's owed. But of course she's owed severance. Now, her question was, how long do I have to go after them? Well, it's 2 years. And that's very important for our viewers to remember. It's 2 years. If you lost your job, to pursue your severance, you have 2 years from when you lost your job. Not 2 years in an hour, not 2 years in a day. It's 2 years. Maximum, I would not recommend waiting 2 years, but that's how long you have. I get calls all the time for people who were let go 3 years, 5 years, 10 years ago, and they realize, having heard our shows, that they were owed much more and they didn't do anything about it at the time, and now they may be out of time. Don't let that happen to you if you lost your job.
I remember we had a call on the radio show once. The guy was let go in the 70s.
Just
little late.
Slightly.
A little bit.
If you called me 40 years ago, we'd be in business, but now can't help you, dude. Yeah.
Two terms you know, employee and independent contractor. The latter sometimes a gray area as to what it is, and if you are one, maybe you think you are, and you've been working for decades under the impression that you are an independent contractor. Want to clear this up for you now. Okay, right off the top, exactly what is the difference between an employee and an independent contractor?
Well, the difference is actually significant because an employee is someone that has a regular job, that goes to work for their employer, that takes direction and supervision from their employer, gets paid for the work done, and is not someone that's in business for themselves. A business person, someone that has their own business, is an independent contractor. A plumber. Best example, plumber, electrician. When you call a plumber because you have a plumbing problem, and that plumber comes in, fixes the job, and goes away, that plumber is not your employee. They're an independent contractor. They're in the plumbing business, and you hire them for their services. An employee is very different. An employee has a regular job, consistent. Doesn't matter if it's full-time or part-time, but it's consistent. And they don't have their own tools, they don't have their own equipment. The problem, John, is many people, I see this every day, one of the biggest issues ever in employment law, many people are misclassified. They're being called independent contractors when they're not. They have a job, they're employees in the eyes of the law, not independent contractors. They're not like the plumber, and that's very important for us to talk about.
Based on that already, some of the viewers may be scratching their head going, oh, now I don't know if I am or not. How do you know if you've been misclassified?
Well, you simply ask yourself, do I have a job? Do I have a job or do I have a business? Very different things, okay? If you have a job, you are an employee. And how do you know if you have a job? Well, because you're going to wake up tomorrow, you're going to go do your job, whether you do it from home or somewhere else. You're going to report to someone. You're going to take direction from them. You're going to represent yourself as being part of that company. If that is you, and if you've been doing this for a while, you are an employee. An independent contractor doesn't have a regular job. They have many clients, they have many customers, they go all over the place. They don't have direction, they don't take direction from someone than their own boss. So if you're not your own boss, you are an employee. And it doesn't matter, this is key, John, it doesn't matter what you signed. It doesn't matter what a piece of paper may say. It doesn't matter how you pay your taxes. It doesn't matter what the company believes that you are. If you have a job, you are an employee.
How common is misclassification of being an independent contractor?
You know, it happens all the time. And you know, our governments try to deal with that here in Ontario and beyond. And it's still a huge problem. And the reason there's a lot of misclassification, because it's cheaper for a company to have an independent contractor. You don't have to worry about pesky things such as overtime and vacation pay and termination pay. You don't have to have a payroll system. You don't have to pay into the government EI and CPP, so it's cheaper. So a lot of companies say, hey, I know how to save money. I'm going to hire an independent contractor, but they really are hiring an employee. That's illegal. If you've been misclassified, you really have all the rights of an employee. And if you continue to misclassify yourself or the company misclassifies you, there could also be some tax consequences.
So I'm on the outside now looking in, watching this show, going, you know what? I think now that you mentioned all this so far, I think I really am an employee. What's the first step? What do I do?
Well, you know, it's a problem. You are taking a risk by continuing to do that, right. Number one, because it's a problem. At some point, CRA, our friends at CRA may look at this and say, no, you are an employee and you've been paying your taxes wrong, you've been getting deductions, there's going to be fines and penalties, etc. It's a bad place to be. What you could do is you can tell the company, or through me or through the Ministry of Labor, that I am an employee and you owe me overtime, you owe me vacation pay, and have that misclassification corrected. What most people choose to do is they choose not to deal with that issue until their employment, quote-unquote employment, is being terminated. And at that point, the company may say, oh, we don't owe you any severance because you're an independent contractor. Right. But wait a second, I now know I'm an employee, so we deal with it when it comes time to get severance. So you can deal with it now and correct that misclassification, or I guess you can continue as you are and deal with it when your employment is terminated, because at that point, it could be a matter of tens of thousands of dollars in severance that are owed to you.
That's the advice for the employee or independent contractor. How about the employer?
Well, if you're going to have someone being there as a regular person doing a job for you, hire them as an employee, because you, the employer, are taking a risk by misclassifying. With CRA, with the Ministry of Labor, don't do it. If you're going to have someone come in occasionally to manage your IT, you know, to make sure your computers are running, and that's okay. That IT person probably has many people that they serve, and that's an independent contractor. But if you're going to have someone dealing with your customers, doing a regular job, dealing closely with your business, maybe doing your bookkeeping, your accounting, that person is an employee. And you calling them an independent contractor doesn't change that. So it's important to remember, if it looks like an employee, acts like an employee, it's an employee, and you calling them something else only means liability for you.
Assault by a coworker and the lack of response from the employer, that's coming up, and we'll get to the severance pay calculator. Short break, stick around, 1-855-821-5900. You'll want to reach out to Lior anytime. Lots more Employment Hour in 30 is on the way.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Hi there, welcome back to Employment Hour in 30. We like to do this part of the show as we focus on the severance pay calculator. Take it away, my brother.
Severancepaycalculator.com. We mentioned it in the previous segment. A tool that I created, 6-7 years ago now, to allow anyone and everyone to find out how much they're owed if they lost their job. It's an important piece of information to have. It's important because it's a lot of money. If severance was, $50, $100, you may not care as much. It's not going to change your life. But severance oftentimes can be months and months of pay, up to 2 years of pay, and even a bit more in some situations. So severancepaycalculator.com, the very place you go to if you lost your job, if you're worried about losing your job, or if you're just curious and interested. Check it out right now. Go grab your smartphone, your laptop, go to severancepaycalculator.com. And when you're there, you're going to answer 3 questions. Your age, your position, the length of your employment, and guess what? You're done. That's it. It's free, it's anonymous, it's easy to use, and it's a lot more, by the way, than a week per year of service that you're owed. Check it out. Spoiler alert, whatever number you think in your mind you're actually owed is a lot more, because that's what the law provides. So severancepaycalculator.com.
And there's also an employer mode on there as well. If you're an employer and you want to do the right thing, you can use it as well, right?
Absolutely. Employers can find out how much they're owed, what their liability is, and also get some additional tips in terms of how to manage that liability.
Okay, we could talk about it all day, but it's often better to use an example, and I'll run one through here for you, and I know you want to talk about this. 53-year-old Alice worked in digital marketing at a company for 7 years, 7 years. She was fired on a Monday without explanation and offered 7 weeks' pay. That's it. Her friends are telling her to, take the money and run. Are they right?
No, they're not right. And, I'm sure her friends mean well and want to help her and they care about her. But unless they're legally qualified as employment lawyers, they should not be giving advice about things like this. I've seen so many good friends, good family members give the wrong advice, and as a result, people losing out on their severance. So no, that's wrong. Of course, after 7 years, she's owed a lot more than 7 weeks' pay. There's a huge misconception that all you get is a week per year, or some people say 2 weeks per year. Wrong, wrong, wrong. It's not that. It's much more. Well, rather than me just tell you how much he's owed, anyone can find out. So let's plug that into the severancepaycalculator.com website. So she's in a professional role, 7 years of service, 53 years old based on this scenario, and she was offered 7 weeks' pay. Well, guess what? She's owed 8 to 9 months pay, not weeks, months pay. Now, for example, if her salary was $55,000, that's a difference of over $30,000. $30,000. And this is only after 7 years of employment. Can you imagine if she had worked there for 27 years, that difference, that delta would have been even more significant. 8 to 9 months for her. That's why it's so important to check out severancepaycalculator.com. If you haven't, if you don't use it when you need it, you're going to lose out.
Moral of the story, don't take the money and run.
No,
don't take the money and run.
Hey, if they offered her 12 months instead of 8 to 9, take the money and run. But at least know what you're actually owed first. That's why you go to the severance calculator.
EmploymentHourTV.ca. Again, that is a resource to find all things about this show and where you can find our radio show and catch that on a weekly basis. Phone calls from the show. We play them back and we comment on them. Number 3, I guess, for the show today, right here.
I was recently assaulted at my work by a coworker. I asked my employer, you got to do something about this. You got to write her up or do something. He failed to do anything about the situation. The office now is more aggressive towards me, scrutinizing my work, and it looks like they're conspiring to dismiss me. 4th year coming up in the insurance sector, mid-40s.
Right.
Oh, okay.
Well, here's the thing, John. It's workplace violence is a big issue. It's an important issue, and it's an issue that employers have to take seriously. If you raise a violence or even potential violence issue with the employer, they, number one, the employer has to investigate it seriously, either themselves or bring in an outside investigator, and take measures to fix the problem if it has merits. An employer cannot ignore it. It doesn't matter if they think it's minor. It doesn't matter, even if it happens outside of the workplace.
Right.
If 2 co-workers have a violent incident outside of the workplace, there's a good chance it may translate into the workplace. So the employer has to deal with it. And the way you don't deal with it is you don't fire the victim. You don't let the person that complained go, because that's illegal. That's a reprisal. That's a violation of the Employment Standards Act. It could be a violation of the Human Rights Code. It's wrong and it's illegal. So if this person now thinks that there's going to be repercussions against him, they're trying to push him, that company is doing something illegal. And even the failure to act in response to the violence complaint is in itself could be a constructive dismissal. So I'd have this person call me as soon as possible. We may be able to get him out of there with compensation. At the very least, he should know that if the company does let him go, there's going to be significant repercussions. So not be worried. There's going to be consequences.
Easy to reach out, 1-855-821-5900. Coming up here as we go into a short break, choosing between resignation or demotion and how overtime factors into severance pay. That is all on the way on Employment Hour in 30. Hang on.
You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. Employment Hour in 30. Lior Samfiru, John Scholes. We cover a lot of topics here when it comes to your workplace and your employment. We also have a radio show. EmploymentHourTV.ca is the resource to find where you can catch the show on a weekly basis. From it, phone calls aplenty. We like to play them back, of course, on this show and get you to comment and dissect and reflect on those, Lior. So we'll get to another one right now.
Friend of mine has recently been fired from her job. She worked for a really big international company. She wasn't given any reasons for her dismissal. She was under a performance review, but there wasn't any detailing in the performance review itself that had tangibles associated with it. And she was basically walked out of the job and then only gave her 2 weeks. She worked there full-time for a year, and prior to that, she was on contract for a full year as well.
The old week per year.
All week per year, the classic week per year.
Yep.
But, let's start by talking about this performance review or performance improvement plan. Just because you're on a performance improvement plan does not mean you could be let go without severance. In other words, it doesn't mean you could be let go for cause. So even if you're struggling with your job and the company has brought up some concerns and they put you on a performance improvement plan to try to improve, that does not mean that just because you can't improve, you can be let go for cause. Remember, it's very difficult, in some cases almost impossible, frankly, to let someone go for cause. It's the worst penalty for the worst offender. So the fact that you're struggling and you're doing your best, but you're not there yet performance-wise, does not mean that the company can let you go for cause. Now, remember, they can let you go without cause.
Yep.
In other words, with severance. They absolutely could do that at any time, pretty much. So for this person, based on what they're saying, it wouldn't be a termination for cause. So it really comes down to severance. All roads lead back to severance eventually. So let's talk about what this person's owed. So this person's been there for 2 years, was offered 2 weeks, and I bet you if she consulted with her friends, they'd say, it's a good offer.
That's
it's
right.
Standard.
That's
You're good.
Standard.
Well, it's not. And our regular viewers will say, hey, go to severancepaycalculator.com. Well, let's do that. Okay, let's go to severancepaycalculator.com. I plugged in the information. You can see on the screen right there, given her age, position, length of employment, and the 2 weeks she was offered, she's actually owed 4 to 6 months' pay. Now, we don't know her salary, but if her salary was $64,000, that's about a $20,000 difference, potentially as much as $29,000 difference. So it's a huge, huge, huge difference. Again, even after 2 years, she could get as much as 6 months' pay, not 2 weeks. So again, reason number 2047 to go to severancepaycalculator.com to get some advice if you lose your job.
Another great place for you to go if you want to ask questions, either on phone call, email, of course. There's also terminationquestions.com. There's a drop-down manual. Pretty high probability that your question has been asked and answered in depth. If not, leave it there, and Lior, a member of his team, will get to it. Example, again, terminationquestions.com is where this comes from. It says, my employer told me that this is a nice choice, I can either resign or take a demotion. Which one should I choose?
Well, how about none of the above?
Door number 3.
Door number 3, please and thank you. Well, the reason for that is, number one, the employer can't make you take a demotion. That's a constructive dismissal. So right off the bat, a demotion, assuming it's a real demotion, it's not just a name change. If it's a real demotion, you can treat that as a constructive dismissal. So that's right off the bat should be a non-starter. And then resignation. Your employer can't tell you your choice is to do this or to resign. No. You're the only one that gets to decide whether you resign. Why? Because a resignation, by definition, is something that you do voluntarily, you do unilaterally, not because someone tells you. So if someone tells you you have no choice but to resign, and you resign, guess what? That's a termination. Because you didn't decide you didn't want to work there. The company decided that. So what should this person do? Say, no, thank you. I'm going to continue working in my other role unless you force the demotion, in which case it's a constructive dismissal, or you decide to let me go and have to pay me severance. So no, don't resign, because if you resign, the company may say, we don't owe you severance because you resigned. No. Don't make it easy on the company in a situation where the company decided they don't want you to work there. If they've decided that, let them do it legally. Let them do it properly. Terminate your employment, pay you the full severance that you're owed, and move on. Don't resign unless it's your choice.
Got time to squeeze another one in here quickly. Terminationquestions.com is the resource. Says, I was just let go. I've been offered an additional 2 weeks' pay to release any future claims to sue. In the last 12 months, I worked over 500 overtime hours. Will signing the release preclude me from filing a claim with the Ministry of Labor?
Absolutely. So any termination letter, any severance package comes with a document, right, usually on the last page, called a release, or a full and final release. And what that document says is that once you've signed it, that's it. You've given up all your rights to pursue anything else, to ask for anything else. You can't realize later they owe me this or they owe me that. That's it. You've given all that up. You've released the company from any further obligations. So what does that mean? It means you cannot and should not ever sign off on that severance package, sign off on that release, unless you've received everything you should have. So if you're owed overtime, well, you can't sign that release because then you can't pursue your entitlements. If you're owed vacation pay, same thing. If you're owed more severance, you can't sign it. So you only sign that severance package when we've dotted our I's, we've crossed our T's, we've got everything where we're owed. And call me if that happens. Let me tell you what you're owed. Let me tell you if you should be signing it. I've had people call me many times, and it breaks my heart sometimes, when they call me after they signed, realizing that was a mistake, and they're stuck.
Thousands of dollars.
I cannot get them out of it. Thousands, tens of thousands. Don't let that happen to you. Please don't sign that release unless you know you've got everything you're owed.
General rule, Ministry of Labor, for severance, not the place to go.
Overtime, yes. Vacation pay, yes, absolutely. Not when you lost your job. Not about severance. They can only help you with respect to your minimum entitlements. Again, not your full entitlements. Severancepaycalculator.com is the place to go to. Consulting with me is the place to go to, not the Ministry of Labor.
Done for another day. 1-855-821-5900 to reach out. Help at employmentlawyer.ca, and to catch things about this show and the radio show as well, employmenthourtv.ca as well. Till next time, this has been Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.